Good morning, everybody. Just let the room fill up for 20-30 seconds, and then I'll make some introductions and we'll get going. So just bear with us for a little bit, please. Right, good morning, everybody. I know we've got a lot to get through over the next 60 minutes, so I will start us off, if I may. Good morning to everybody. I hope everybody's well, and I hope you enjoy the session that's coming up. As it says on the screen, this is an employment law review and what to expect in 2024. Before we get going, just 2 or 3 housekeeping points, if I may. Please, if you have any sound or visual issues, please take a look at your own system first, your own Wi-Fi, your own connectivity. We often find if there are issues, that's where the problem lies. If it's a wider issue, and I hope there isn't, then we will look to resolve that as quickly and as efficiently as possible. The next 2 things I think are probably the most important. There is a Q&A button at the bottom of your screen. There is a chat box function at the bottom of your screen. I see a good number of you already sort of saying good morning, hello in the chat box. These sessions come to life because of your questions, your observations, your experiences. Please use those 2 boxes to ask questions and to put your experiences and your observations in, please. The session is recorded, and we will talk with Euan afterwards just to ensure that slides and a recording can be shared with everybody, but please bear with us on that. Just let me make a brief introduction, and it's very much a welcome back in a way to Euan Lawrence. Euan has joined us. I think probably this is the 3rd year running that we've run this webinar at and around this time of year. So Euan, thank you for rejoining us. It's always a pleasure to host you, and I know the members get a lot out of your presentation and your talk. For those of you who've not seen Euan previously or before, Euan Lawrence is a partner within the employment team at Blacks Solicitors. Euan specialises on her strengths in a number of areas, including drafting and negotiating settlement agreements, advising on exit strategies, preparing service agreements, advising on TUPE transfers, and contesting employment tribunal claims. He works with a broad client base, but it is predominantly owner-managed businesses and individual employees. Euan has also been recognised by the Legal 500 for his enthusiastic and extremely dedicated approach. So, Euan, thank you for joining us. It's also a pleasure to welcome Adam Megson. Adam joined Blacks in 2022 and is part of the Solicitor Apprenticeship Programme, which involves Adam both studying at university whilst working at Blacks. Adam is currently seated within the employment team, working very closely with Euan, but has also already spent time in the residential property and conveyancing and property litigation seats. So, Adam, it's a pleasure to have you joining us, and thank you for doing so. I also just want to sort of say thank you to Nicola Marks, who is there in the background and will be dealing with the questions that come through. So, Nicola, thank you for your involvement and participation. Euan, enough from me. I will hand over to you, and thank you very much indeed for your session today.
Thanks very much indeed, Jonathan, for that introduction. And good morning, everybody, and thank you for joining us today for what we hope will be an informative and helpful exploration of the recent and expected changes in employment law. As Jonathan mentioned, you do have access to both the chat and the Q&A function. As I can see that the chat function has already been used for a number of hellos and so on and so forth, if we could keep the questions that you are referring to us within the Q&A function, then that's going to help a great deal when it comes to us knowing what questions are directed at us. As I say, all being well, we'll have some time at the end to go through some questions. But we do have a lot to cover. If we don't have time to cover all your questions, then of course we can deal with those in a follow-up. So what did 2023 bring to employment law? On screen now are the areas that we intend to touch upon during this part of the webinar. We'll be looking at menopause in the workplace, historical holiday pay underpayments, particularly a recent case that's changed the 3-month automatic break in a series of deductions. I'll explain that later. Reforms to the working time regulations, holiday pay and TUPE. And then I'll briefly discuss Protection from Redundancy, Pregnancy and Family Leave Act 2023 and the implications of that before going on to a few notable cases from last year. So to start with menopause in the workplace, first of all, this has been a developing area for a few years now, and I'm going to first cover what action the government are proposing to take in a bid to ensure menopausal women are supported in the workplace. So in 2022, the Women and Equalities Committee published its report, Menopause in the Workplace. This followed up on its 2021 inquiry. And in September of 2023, the CIPD published its manifesto for good work, which included a recommendation for a campaign to create more menopause-friendly workplaces. The CIPD then published its annual Health and Wellbeing at Work survey, showing a significant rise in the number of organisations having policy provision for menopause. In October last year, the government published a policy paper providing an update on the work of the Menopause Employment Champion, a new guidance for employers. And this new guidance signposts employers to its Help to Grow for Menopause support. Also, in October last year, the All-Party Parliamentary Group published a manifesto for menopause, calling on all political parties to commit to 7 reforms ahead of the next general election. The employment aspects included requiring employers with over 250 employees to introduce menopause action plans to support employees experiencing the menopause, providing specific guidance to SMEs to support employees going through the menopause, introducing tax incentives to encourage employers to integrate menopause into occupational health. However, the government has confirmed that it does not intend to amend the Equality Act 2010 to add menopause as a protected characteristic, and other protected characteristics being things like age, religion, race, sexual orientation, etc. Nor does it propose to implement the provisions relating to combined discrimination within the Equality Act. So in that light, we're going to look at the Equality Act 2010 and the Employment Rights Act 1996 to identify the types of claims that menopausal women can and do make against their employers under existing legislation. So looking at menopause and discrimination, a recent analysis of court records by Menopause Experts Group found that the number of tribunal cases which cite menopause increased by 44% in 2021. Employers therefore need to be aware of the potential discrimination claims that may arise because of their treatment of those experiencing menopause. Now, as I mentioned, the government's confirmed that it does not intend to make any menopause-related changes to the Equality Act, including making menopause a specific protected characteristic or implementing the combined discrimination provisions of Section 14. And just to explain what that means briefly, when the Equality Act was originally drafted, they proposed to have a specific section dealing with so-called dual protected characteristic discrimination. And the menopause falls broadly into this because, of course, you've got to be of a certain age, generally speaking, of a certain gender, and arguably the symptoms constitute disabilities. So whilst the government hasn't proposed to actually legislate about the dual discrimination provisions, those experiencing menopause may still be able to bring discrimination claims relating to the existing protected characteristics of age, disability, and/or sex. Also, trans people who are experiencing menopause symptoms may be able to bring discrimination claims based on the protected characteristic of gender reassignment. Moving on to the issue of the menopause and unfair dismissal. Now, when dismissing an employee who is experiencing menopause symptoms, an employer must bear in mind its usual obligations when it comes to a fair process and fair dismissal. This means that dismissal must be for one of the potentially fair reasons specified in Section 98 of the Employment Rights Act 1996, namely capability or qualifications, conduct, redundancy, statutory restriction, or some other substantial reason. In all the circumstances, including the employer's size and administrative resources, the employer must act reasonably when it decides to dismiss. And cases such as Davies and Matthews against Birchman, Dyson, Bell show that menopause-related unfair dismissal claims often concern employees who were dismissed for misconduct. Now, as in all misconduct dismissals, an employer must demonstrate that it's carried out a reasonable investigation before the dismissal. And where an employee being disciplined is experiencing menopause and argues that this affected or caused their behaviour, it's likely to be unfair for the employer to dismiss without at least considering whether this could have been the case. However, misconduct dismissal may be fair without having taken into account the employee's menopause, where it is absolutely clear that having considered the fact of the menopause would have made no difference to the employer's decision to dismiss. It should be noted, however, that employers only like to be able to show that this is the case in rare scenarios concerning, for example, serious gross misconduct. Punching your manager might be one of those. Where a tribunal finds that a misconduct dismissal is unfair because the employer has failed to consider the menopause, the employer may be able to argue that either a so-called Polke deduction should apply to reduce the compensation, in some cases to zero, because the dismissal would have occurred anyway, even if a fair process had been followed, or that compensation should be reduced because of the employee's contributory fault. Now, where an employer is considering a capability dismissal because of the employee's poor performance, but the employee argues that menopause has affected their performance, it's likely to be unfair for the employer to dismiss without, again, having first considered what effect menopause may have had, and it may be necessary to get expert medical evidence in that respect. However, as is the case for misconduct dismissal, the employment tribunal can reduce compensation by making the aforementioned Polke deduction or contributory fault deductions for a performance dismissal as well. And there's no authority of which we are aware relating to menopause dismissals for the other potentially fair reasons for dismissal, as I mentioned, redundancy, some other substantial reason, etc. However, taking into account the basic principles established in the case law referred to earlier, it'd be sensible for an employer to properly explore and consider in advance of any dismissal any menopause-related issues raised by the employee during the dismissal process, which may be relevant to the decision to dismiss. So next we come on to managing menopause in the workplace. So how can you manage menopause issues in your workplace, or indeed, how can your clients do this? A helpful place to start is to look at the survey results and reports from the License of the Fawcett Society and the British Standards Institution as to what menopausal women experience in the workplace and why they leave the workplace early. Of the UK women surveyed, the report from the British Standards Institution found that 20% mentioned health or well-being considerations for the menopause as a barrier to continuing in work. 54% would find it difficult to raise health and menopause-related issues with their employer, and 60% would be uncomfortable raising these issues with a male manager. 71% said formal policies to address personal health and well-being issues such as menopause would be helpful. However, only 4% were aware of such policies in their organisation. Now, it's clear from these figures that going through menopause whilst working may have a profound impact on an employee's experience in the workplace. It's therefore crucial that an employer has policies and procedures in place to accommodate and support employees through menopause transition. There are a lot of resources and guidance now available to employers to help them manage menopausal issues in the workplace, including the ACAS guidance on menopause at work and the Help to Grow guidance on the government website that I mentioned earlier. Other practical measures are displayed on this slide and include training staff on menopause, making health and safety adjustments for the menopause, implementing a menopause policy, encouraging open conversations, and appointing a menopause champion. So with that being said, I'm going to hand over to Adam to talk to you a bit about historical holiday pay underpayments.
Cheers, Euan. Thank you. So as Euan's just said, we're going to move on to historical holiday underpayments and the change to the 3-month rule that has come in now, thanks to the case of the Chief Constable of the Police Service of Northern Ireland versus Agnew, which some of you may have read, may have heard about it. But before we go into that, I think it's important that we take a step back and look at what came before Agnew, which was the case of Bear Scotland, whereby the Employment Appeal Tribunal held that a 3-month gap broke a series of deductions of holiday pay underpayments. In that case, the Employment Appeal Tribunal also held that an employer could decide when each of the different types of holiday should be taken. And this meant that an employer could increase the likelihood of there being a 3-month gap between underpayments if it decided that the holiday derived from the Working Time Directive. However, thanks to Agnew, this position has now completely changed. And because of Agnew, the new case, it's increased the potential financial damage that an employer could face if it fails to pay its employees the correct amount of holiday pay. So in the case of Agnew, the PSNI, the Police Service of Northern Ireland, are now likely to be stuck with a bill of around about £40 million simply because it failed to pay its staff the correct amount. The claim itself was brought by the trade union Unison on behalf of Mr. Agnew and 3,700 of his colleagues. And they argued that the holiday pay should have been calculated by taking into account their normal pay, which included overtime, rather than their basic pay, which didn't. And this was accepted, that there had been an underpayment of holiday pay, but the question for the Supreme Court was to determine if those underpayments constituted a series of underpayments, and if so, how far back could the employees claim? Now, as I mentioned earlier, the previous case of Bear Scotland held that a period of more than 3 months between 2 alleged underpayments would automatically represent a break in the chain of the series. However, in Agnew, the Supreme Court found that when determining if there'd been a series of underpayments, it was necessary to look out for the reasons behind the underpayments. Now, the Supreme Court considered that if the underpayments were similar, and as a result of a common fault, which is the case in Agnew, which the PSNI only paid their employees basic pay when they were on holiday. If there's a common fault, then a series of underpayments will exist, irrespective of whether there was a gap of over 3 months, which used to be the case in Bear Scotland. Nevertheless, the series of deductions in Agnew was found to be a question of fact, and the judgment states that this has to be decided on a case-by-case basis. Now, it's worth remembering that in the UK, employees can only claim for underpaid holiday pay going back up to 2 years, which doesn't apply to Northern Ireland, which is why Agnew, the PSNI have been stuck with a £40 million bill because it's allowed them to claim back a lot further than 2 years. The case of Agnew doesn't change the limits, so there is still that 2-year limit for the rest of the UK. However, it does allow employees to now link together underpayments in a series, which previously wouldn't have been allowed in the case of Bear Scotland. And to conclude on that, the Supreme Court's guidance on what amounts to a series of deductions is pretty wide, to be fair. It all depends on the circumstances. It's very open to interpretation. And whilst it is favourable towards claimants, it isn't a closed door for the respondents. So sticking with the theme of holiday pay, we're going to move on to the reforms that are coming into the working time regulations, holiday pay and TUPE. So the new reforms that are coming into the regulations are an effort from the government to try and reduce and update the regulations after Brexit. Now, the changes there are in response to 2 government consultations this year, the first one being on TUPE and the second one being on calculating holiday entitlement for irregular hours workers and part-year workers. The second consultation sought views on whether a 52-week reference period for calculating holiday entitlement was the best way to address the repercussions of the ruling in Harper Trust v Brazel, or Brazel, however you want to say it. Now, this ruling resulted in part-time workers being entitled to a lesser annual leave entitlement than part-year workers who had worked the exact same number of hours over the year. Now, in its draft statutory instrument, the government has ditched this original proposal in favour of a simplified approach, introducing an accrual method, which ironically was a method that was used before the judgment in Harper Trust. Now, the government are proposing to introduce this accrual method to calculate annual leave entitlement at 12.07% of hours worked in a pay period for irregular hours workers and part-year workers, which could include some agency workers, but let's not get into worker status, as that's a very, very tricky subject, to put it that way. So for the avoidance of doubt, other workers will come to accrue annual leave in their first year of employment, as they do now, by receiving 1/12 of the statutory entitlement on the first day of each month and pro rata thereafter. Now, the government are also intending on reinstating various pieces of retained EU case law in relation to carrying over annual leave, and when a worker is unable to take their annual leave due to being on sick leave or family-related leave, such as maternity or paternity leave. In addition, there will also be clarity on the definition of normal remuneration for holiday pay purposes, which would include commission payments, bonuses, and other payments such as regular overtime. Regarding TUPE regulations, currently, all businesses with 10 or more employees are required to arrange an election to elect an employee representative for affected employees, if there's not one already in place. But the government are now proposing to remove that requirement for any employers who have 50 or less employees, or for any businesses of a size that involve the transfer of fewer than 10 employees. So either way, no matter the size of your business, if you're doing a consultation with your employees, it should be carried out directly with those who are affected by the TUPE transfer. Further changes aim to make it clearer for employers to on their obligations regarding working time, recording working time, sorry. This has come from the recent European Court of Justice ruling in Deutsche Bank, which held that working hours records must be kept for the majority of the workforce. Now, the new regulations would make it clear that businesses don't have to keep a record of workers' daily working hours as set out in the ruling, but instead businesses simply need to ensure adequate proportionate records in the context of their workplace and particular working patterns. Now, I'm going to hand back to Euan, who is now going to talk you through the Protection from Redundancy, Pregnancy and Family Leave Act 2023.
Thanks, Adam. Yes, the catchily titled Protection from Redundancy in brackets Pregnancy and Family Leave close brackets Act 2023. This act provides a power for regulations to be made to extend the right to be offered suitable alternative vacancies in a redundancy situation, so that it will apply during pregnancy and for a period after pregnancy or maternity, adoption or shared parental leave. And that's expected to be a period of 6 months after returning to work. Now, currently, the Employment Rights Act 1996 allows the Secretary of State to make regulations concerning redundancy during periods of maternity leave, adoption leave, or shared parental leave. For example, before making a woman on maternity leave redundant, an employer must offer her a suitable alternative vacancy where one's available with the employer or an associated employer. However, this bill amends the Employment Rights Act 1996 to enable regulation to come forward to provide protection against redundancy during or after an individual taking the relevant leave. And it'll also add a new provision to the Act to enable regulation to come forward to provide allowing for regulations about redundancy during or after a protected period of pregnancy. Now, whilst the detail will be provided by the regulations, the explanatory notes to the bill suggest that by extending protection after a protected period of pregnancy, a woman who has, for example, miscarried before informing her employer of her pregnancy will still benefit from the redundancy protection. The Act itself came into force in July of last year, but no firm date has been set for the implementation of the necessary regulations. The government has referred to secondary legislation being laid in due course, which is the government's favourite expression for doing things in due course. Anyway, if we can now move on to talking about a few notable cases from 2023. The first one we are very immodestly going to talk about was one that we were involved in, representing the successful party, that of Linsky against Direct Line Insurance Services Limited. was our colleague Anna in the employment team, who acted for the claimant alongside Nicola. Mrs. Linsky worked as a telesales consultant and was impacted by her menopausal symptoms such as low mood and anxiety. Her performance at work was criticised and formal performance management proceedings were commenced. Mrs. Linsky's manager sought advice from senior management and was offered a different role intended to be better for her, which she accepted. However, complaints were received relating to her conduct to customers, and she was signed off sick following an occupational health report, deeming her as likely to be disabled for the purposes of the Equality Act. Mrs. Linsky sought claims or pursued claims for constructive dismissal, sex and age discrimination and harassment. And the tribunal held in that case that many of Mrs. Linsky's claims for discrimination arising from disability due to the failure of the employer to make reasonable adjustments had been made out. They did dismiss her claim for constructive dismissal and age and sex discrimination. But the case is a significant one, which demonstrates an employer's responsibilities to make reasonable adjustments when an employee is affected with menopausal symptoms. And hopefully that's illustrative of what I was talking about in relation to how employers need to look after people with the menopause. I'll pass over to Adam to talk about the next case.
Thank you, Euan. So the next case that we'll be talking about will be Union of Shop, Distributive and Allied Workers and Oars versus Tesco's. The claimant can be shortened to USDOR, which is how I'm going to refer to them throughout. So in around 2007, Tesco began a restructure which saw the closure of a few of their sites and stores and resulted in relocations. They wanted to keep on their most experienced employees by way of redundancy because of the restructure, and they agreed with USDOR that an individual contractual right for retained pay would be implemented for existing employees. Now, Tesco went on to say that the retained pay was protected for life at the new Tesco contract site and confirmed that it would remain for the entirety of the employee's employment with them. Fast forward to January 2021, Tesco announced that it would be removing the entitlement to retained pay and asked all employees who had such entitlement, and also said that they would fire and rehire any individuals who did not agree with the contractual variation. So following this, USDOR and 3 employees of Tesco issued a claim against them to seek a declaration that there was an implied term in their employment contracts which prevented Tesco from taking such action. And as a result of this, the High Court issued an injunction which would prevent Tesco from their proposed fire and rehire action, stating that it was a mutual intention that the entitlement to retained pay would exist as long as each affected employee was employed in their role. Now, Tesco appealed this. They appealed the High Court decision to the Court of Appeal, who found that the High Court had erred in their decision, particularly on the point about mutual intention. The Court of Appeal confirmed in their decision that there was a lack of clarity on how the term permanent was interpreted by both parties, and that the entitlement to retained pay would only last as long as the employment contract lasted. So USDOR appealed the Court of Appeal's decision, and the case is due to be heard at the Supreme Court on the 23rd and 24th of April of this year. Now, it's probably a good time to talk about the statutory code of practice on fire and rehire. So ACAS have issued guidance on this. They issued it in 2021, which states that employers should think carefully before taking the decision to fire and rehire in order to amend their employees' terms and conditions. And this practice should only be used as a very last resort. Following on from this, and also the P&O ferries dismissals, which I'm sure the vast majority of you will have heard about as it's been in the news quite a lot. The government announced that a new statutory code of practice would be published on the practice of fire and rehire. The code has been designed to ensure that employees take all reasonable steps to explore alternatives to dismissal and also engage in meaningful consultations with the employees. Now, the code will apply when employers want to make changes to its employees' contract of employment, and they envisage that the employees won't agree to the proposed changes as a result. They are considering dismissing the affected employees and re-engaging them on the amended terms. Now, The code will also offer a step-by-step process that employers should follow. Depending on whether you do or not, that's up to you, but you should follow it, just so that an agreed solution can be reached. And this code is expected to be published in spring, around about springtime of this year. So I'll hand back to Euan to talk about Uber.
Thanks very much, Adam. And
Right.
just quickly dealing with that last point, whilst it is obviously it's up to you whether you deal you comply with any aspect of the law or the codes. There could be penalties if you don't. It's likely that if you fail to comply with the statutory code, then any award made against you could be uplifted, I anticipate. So very quickly to talk about the Farrar against Uber London case, an extension of the long-running many Uber cases. This is one where an employment tribunal has awarded James Farrar, who's a former Uber driver, £22,960.85, respective his holiday pay and alleged unlawful deduction from his wages owed to him for more than 7 years. The tribunal upheld his claims for breach of the working time regulations in relation to his accrued but untaken holiday pay. The unlawful deduction from wages claim relating to Uber's failure to pay the national minimum wage once the driver's waiting time was factored in. And the final compensation payment was ultimately agreed with Uber's representative and then confirmed in a consent order issued by the tribunal. And Mr. Farrar was one of the parties involved in the original litigation, culminating in the 2021 Supreme Court decision that established that Uber drivers are workers for the purposes of the employment legislation. The Supreme Court also held that the driver's working time includes any period when they are logged into the Uber app and are ready and willing to accept trips. So following the ruling, settlements have been agreed apparently with more than 70,000 drivers. So now back over to Adam to talk about 2024.
Yep, thank you, Euan. So what will 2024 bring? Well, wouldn't we all like to know? So we'll be looking at the employment law changes that will be coming in. Quite a few acts have been given royal assent this year and should hopefully be coming into force in 2024. The ones that we're going to cover are the Equality Act 2010, the amendments to the regulations 2023, the Workers' Predictable Terms and Conditions Act 2023, and the Employment Allocation of TUPEs Act 2023. We'll also be covering the usual statutory increases that are due to come in April, artificial intelligence, which I'm sure you'll all be rather up to date on. It's everywhere these days. It's in the news. Also, what Labour's proposals are ahead of this year's general election, and employment tribunal fees that are to be reintroduced, as well as some case law that's expected in 2024. So we'll start with the Equality Act 2010, Amendment Regulations 2023, which came into force on the 1st of January by virtue of the retained EU law, Revocation Reform Act 2023. Now, the interpretive effects are reproduced by way of amendment to the Equality Act 2010. And the key changes in relation to that are as follows. So to begin with, we've got direct discrimination related to pregnancy, maternity and breastfeeding, which will extend protection in pregnancy and maternity discrimination claims to cover unfavourable treatment after the protected period, where the treatment is because of the pregnancy or pregnancy-related illness during the protected period. The protected period is extended where the right to maternity leave arises from an occupational scheme, which entitles claimants to bring a pregnancy and maternity claim without the need for a comparator. A new section is going to be introduced covering indirect associative discrimination, which will enable a person without a protected characteristic to bring an indirect discrimination claim if they suffer a disadvantage alongside the person with the protected characteristic. So that's an interesting introduction there. Another new section will be inserted to cover discriminatory statements about recruitment, which will mean that a general discriminatory statement made in connection with a relevant recruitment decision may constitute direct discrimination, even if there's no active recruitment exercise and no identifiable victim. And finally, the definition of disability will not only include a person's ability to carry out normal day-to-day activities, but also include a person's ability to participate fully and effectively in working on an equal basis. Sorry. So moving on now to the Workers' Predictable Terms and Conditions Act 2023. So in 2017, there was a review, which was the Taylor Review of Modern Workplaces, which identified the problem of one-sided flexibility, where basically a worker's got no guarantee of work, essentially, to put it bluntly, but they are still expected to be available at very short notice, as and when required by the employer. So, of course, this creates unpredictability to the employee, as well as, income insecurity and a reluctance among workers to assert basic employment rights. This act will give workers and agency workers the right to request more predictable terms and conditions of work where there is a lack of predictability with their work pattern. It'll be possible to make 2 applications in a 12-month period, as is the case with the flexible working regime, which is due to change as well. Employers will be able to refuse requests for certain statutory reasons, which means that employers in industries that rely on unpredictable working arrangements are likely still able to do so. However, they will need to introduce processes for dealing with requests for more predictable working patterns. A minimum service requirement will be 26 weeks, as is the case with all flexible working regimes at the moment. I know that they are thinking of changing the flexible working regime to becoming a day one right, but for predictable working patterns, it is going to stay as 26 weeks. So ACAS have issued a draft statutory code of practice, which is still under consultation, but as the act is due to come into force in September of this year, we'd like to hope that the code comes out relatively soon so that we can advise you on that as and when. But we will keep you posted when the code of practice is published. So I'll hand you back over to Euan, who will be talking you through the allocation of TIPs.
Thank you very much. So this is the Employment Allocation of TIPS Act 2023, which gained royal assent last year. Necessarily, this is only going to affect sectors such as hospitality, where workers and other employees actually receive tips. Often they're only paid national minimum wage and they rely on tips or a service charge to make up their income. This is going to come into force on the 1st of July of this year. Now, whilst cash tips are frequently paid directly to the worker, any tips paid by card are paid directly to the employer, which means that workers are often left out of pocket if the tips are not passed on. The law's been introduced to overhaul tipping practices in the UK and protect over 2 million workers by making it unlawful for employers to withhold their tips. The key points that have been introduced by this act are, firstly, employers must pass on 100% of tips left for staff without any deductions unless they cannot do so for tax purposes. Employers must have in place a written policy confirming that any tips will be distributed fairly and transparently. Employers will need to keep records detailing how tips have been distributed for 3 years from the date the tip was received. Workers have the right to request their tipping record for a particular period, and the employer must respond to the request within 4 weeks. If the employer uses a trunk system, I anticipate any of you who work with hospitality and particularly restaurant businesses will be familiar with, any tips must be paid to the worker no later than the end of the month after which it was received. Agency workers will also benefit from the act in the same way, and employers will need to follow a statutory code of practice. In addition, any breach of the act will entitle a worker to lodge a claim at the Employment Tribunal for reallocation of the tip and or compensation. And like with any employment claim, it must be lodged within 3 months of the alleged breach, subject to any changes that the Labour government may introduce if Labour do indeed come into force for the next election. The Act requires that the total amount of tips received are distributed fairly to workers, so the employer will be left with the financial burden of paying any card processing fees or administrative charges associated with non-cash tips. A possibly unintended consequence of this measure could be that employers in the hospitality sector simply stop accepting tips and gratuities paid by card, resulting in a reduction of tips being paid at all, which would sort of defeat the purposes of the Act. However, As it is expected to come into force on the 1st of July, employers in the hospitality sector needs to start thinking about what they're going to do to ensure that they're compliant with the Act before it comes into force. Now, we're next going to move on to a slide which I'll canter through very quickly about the national minimum wage. There has been, as there always is, increases to the national minimum wage. The headline for the national living wage for those who are 21 or over is it's increased, or is due to increase from the 1st of April to £11.44 per hour. That's a 9.8% increase. You can see the other increases up there, which range between a 9.8% increase and a 21.2% increase for some of the other bandings. The Chancellor also announced during the recent budget that he will be reducing national insurance contributions by TUPE, which of course will benefit 27 million workers. So moving on to the issues of the government, and if Labour get in, what they're proposing to do after what they're currently proposing ahead of the general election. So first of all, £10 minimum wage. Labour is saying that they're going to increase the national minimum wage to £10, which provide workers, they say, with a higher standard of living and more financial security. They're proposing to ban 0 hours contracts. Now, 0 hours contracts, you might be aware, offer uncertain and often unstable employment conditions for workers. And the move aims to provide more stability and predictability in the work arrangements. Although personally, I'm a little bit dubious about how this is going to leave, for example, people doing bar work and so on and so forth, where 0 hours contract seems eminently sensible. But anyway, we'll see what the legislation looks like when it comes out. They're proposing a single worker status. So employees who enjoy a wider scope of employment protections are not currently, which aren't currently enjoyed by workers. So workers do have the right to national minimum wage, paid holiday, protection from unlawful deduction from wages, but they can't bring claims for unfair dismissal, and they're not entitled to statutory payments such as statutory sick pay, maternity pay, or statutory shared parental leave pay, for example. The statutory definitions of workers and employees are not consistent in different pieces of legislation, which can be confusing. So, for example, the Employment Tribunal's test for what is an employee and a self-employed person is subtly different from that used by HM Revenue and Customs for tax purposes, which isn't helpful. And notwithstanding all this, some of you may know that determining employment status comes down to a number of factors, such as personal service, mutuality of obligation, control, with each case being very fact-specific. The tribunals and the courts have been very keen to say that this is not a tick box exercise, which most employers would probably like it to be. So there's no real straightforward test or answer when it comes to establishing employment status. You've got to look at the whole circumstances in the round. As a result of this, Labour apparently plans to launch a consultation on having a single worker status for everyone, except those who are genuinely self-employed. And this would apparently remove any confusion when trying to establish employment status. It would also extend statutory rights for employees to workers. Labour are hoping that introducing a single worker status will not only simplify the framework, but also free up some of the Employment Tribunal's time. Employment Tribunal, of course, are dealing with very lengthy backlogs. Now, you may remember that the Conservative Party did consult on the single worker status, with their results being published in July 2022, and they concluded that the current three-tier approach to employment status was the most appropriate, as it did bring flexibility. If Labour's consultation concludes that a single worker status is deemed to be appropriate, then this will cause a bit of a headache for employers who will need to look at their workforce and establish where changes need to be made to working arrangements and any appropriate policies and procedures. Labour are also suggesting that they're going to make unfair dismissal a day one right. You heard that correctly. So they are apparently going to include the right not to be unfairly dismissed along with the other day one rights, as well as, for example, right to redundancy. Both of those currently require at least 2 years service before you're able to claim for that. And there's also been talk that Labour plan to remove the statutory cap on an unfair dismissal award. We shall see. is all I'll say on that. Finally, there's the right to switch off. Now, this concept was introduced in France in 2017, and Labour looking to introduce it in the UK if they're successful in the next general election. If introduced, it will mean that everyone will have the right to switch off outside of their normal working hours. As many workers are now able to work from home, it's been reported that an increasing number of workers report not being able to switch off and are working out of hours, responding to emails, etc., etc. Introducing such a right will hopefully help with staff morale and could also potentially help with staff retention and improve recruitment. Now I'll hand back over to Adam to talk about artificial intelligence.
Thank you, Euan. So, artificial intelligence, it's in the news all the time at the moment. Just a quick definition. Artificial intelligence is the intelligence of machines or software as opposed to the intelligence of humans. Now, as artificial intelligence is continuing to evolve and advance, it is rapidly changing so many workforces across the world. It really is. And it is a concern for employers and businesses because one of the biggest effects of AI on employment is automation. AI-powered systems can perform tasks that are traditionally done by humans, which inevitably leads to job losses. According to a report by the ONS, around 1.5 million jobs in England are at high risk of being automated in the coming years. Industries such as manufacturing, transportation, retail, they are all particularly vulnerable to automation. But it's not all doom and gloom, because as AI advances and evolves, it also provides new opportunities and a demand for skills. The rise of AI necessitates reskilling and upskilling in the workforce to adapt to the changing job market. Invest in education, training programs focused on AI-related skills, such as data analysis, programming, and even machine learning, as they will all be crucial in the future for the workforce. Ultimately, the impact of AI on employment in the UK will depend on how effectively employers navigate the challenges and opportunities that it presents. Whilst it does have the potential to disrupt employment, it does also offer employers and businesses the opportunity for economic growth and innovation. So, moving on to the Employment Tribunal now. So, back in 2013, which some of you may remember, the Employment Tribunal introduced fees, which ultimately led to a reduction of claims being brought by 53% in the 12 months that followed. Although the fees for 2013 were substantially more than the fees that they are proposing to introduce now. So back in 2013, the proposed fee was £390 for a very, very straightforward claim in the Employment Tribunal. But with more complex cases, the fee could be well over £1,000, up to £1,200, So the fee that they are proposing to introduce now is just a meagre fee of £55, which is hugely, hugely different to what was introduced in 2013. Now, a Supreme Court ruling led to the fees being withdrawn in 2013 as it prevented employees from low-income households from issuing claims, with the Law Society even commenting that justice must never be a luxury for those who can afford it. Now, the government consultation is currently open. It's open until the 25th of March of this year, so not long left. Not long left until it closes. So we are still, it's still in the air as to if it is going to be introduced or not, but we will see. What you think of it, that's your opinion. But yeah, anyway, go back to Euan to talk you through some notable cases that are coming up in 2024.
Thanks very much indeed, Adam. So the first case we're going to have a look at is that of Hope against British Medical Association. So this was a case where the claimant was dismissed for gross misconduct following a series of vexatious grievances against senior managers. The claimant would refuse to take part in the grievance process, which led to the grievances being heard in the claimant's absence and them not being upheld. The BMA claimed that the claimant's conduct throughout the proceedings was frivolous and amounted to an abusive process. The Employment Tribunal held that the dismissal was fair, and the Employment Appeal Tribunal agreed. The case is due to be heard this year at the Court of Appeal, and it's hoped that the Court of Appeal decision will provide some helpful guidance to employers when it comes to dealing with employees who are raising grievances in bad faith, potentially repeatedly, vexatiously, abusively, etc. So, do you want to talk about Higgs and Farmers School, Adam?
Yep, I can indeed. So Higgs v. Farmers School, the claimant was a Christian, was employed as a pastoral administrator and had regular contact with pupils, parents, and as it was part of a role. Following information shared by the claimant through a social media account, a complaint was made to the head teacher by a parent who said that the posts contained homophobic and prejudiced views, and they were concerned that the teacher's views may have a negative impact on the students that the claimant comes face to face with, as some were more than likely LGBT+. Following an investigation and disciplinary, the claimant was dismissed for sharing discriminatory views. The claimant issued a claim for discrimination on the grounds of her religious belief, but the Employment Tribunal rejected her claim, citing that her dismissal was not related to her beliefs, but due to the fact that others might perceive her to be homophobic and transphobic because of her social media posts. The Employment Appeal Tribunal disagreed with the Employment Tribunal and concluded that there was sufficient connection between the claimant's beliefs and her dismissal. Now, that decision has been appealed and it is going to the Court of Appeal. So we'll keep you posted as to how that progresses.
And I think it's probably a useful point, Adam, just to quickly identify the criteria that will be analysed by the Court of Appeal when considering this case, and that's what's known as the Granger criteria. Do you want to talk a little bit about that quickly?
Yeah, can do. So the Granger criteria comes from the 2009 Employment Appeal Tribunal case, Granger PLC v Nicholson. And there are 5 criteria that a belief must meet for, well, that's what they'll be testing. They'll be testing these 5 criteria against the claimant's belief. So they are: the belief must be genuinely held. It must be a belief and not simply an opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion, and importance. And finally, it must be worthy of respect in a democratic society, be not incompatible with human dignity, and not conflict with the fundamental rights of others. So they're the 5 criteria that they will be testing in the Court of Appeal. So yeah, we'll see what they make of that.
Grand. Thanks very much, Adam.
Right.
So the last final case that we've got is the Voltex against Bialas case relating to unfair dismissal. So this was a case where the employer had appealed against an employment tribunal's decision that the dismissal of Mr. Bialas was unfair. The employee was dismissed for posting a racist joke on the employer's internet. The employment tribunal outlined the dismissal was unfair because the dismissing officer had some level of misunderstanding and an element of malice. The employer appealed the tribunal's judgment. The issues for the appeal were whether the dismissal of the claimant was within the band of reasonable responses available to a reasonable employer on dismissal, and whether the tribunal's decision was correct. The AT set aside the tribunal's decision, found the dismissal was not unfair. They found that the employee's investigation of the employee's actions was sufficient. The dismissal was not unfair procedurally. And the case is significant in ensuring companies have a thorough process to ensure they adhere to disciplinary proceedings. Now, this case followed a case from 2023 where a Lloyds Bank employee was awarded £490,000 at the Employment Tribunal after being dismissed for using the N-word during a training session. In this case, Mr. Neal was one of over 70,000 employees who attended training on race education. During the session, he asked how he would handle a situation where the N-word was used, but he used the full word rather than the abbreviation. He immediately apologised. Trainers took offence to this and had the following 4 or 5 days off on sick leave as a result of what she perceived to be a slur. And the Lloyds therefore took the decision to dismiss Mr. Neal. The tribunal found in this case that although the word is unquestionably appalling and should be avoided in a professional environment, in these unusual circumstances, no reasonable employer would have dismissed the employee, and a warning would have been appropriate in the circumstances, given Mr. Neal's otherwise long-standing and unblemished service with the company. It should also be mentioned that Mr. Neal was dyslexic. The tribunal found on the balance of probabilities that this was a strong factor which led to how he expressed himself at the training session. So final slide, please, Nick, which is really any questions. Now, there's only one that I can see through on the Q&A function, and that question merely says, is this the same for charity or for a charity? And the answer to that question is bluntly yes. Everything we have described today in the context of employers' obligations apply as much to a charity as they do to a professional services firm, a public sector organisation like the NHS. These rules don't discriminate, albeit the tribunal will often have regard to the size and resources of a particular employee when determining whether there's been a breach, and if so, what award to make. So I think that's all from us for the time being, Jonathan, unless you've got any questions you wanted to ask.
No, I've listened with great intent to both yourself and Adam. You said before we went live that you had a lot to cover. You certainly weren't fibbing on that one, were you? And you've covered a lot, so thank you very much indeed. And I think it's one to watch this space. I would also just say to members who joined us this morning and now just about to approach the afternoon, I think this is an area whereby if you are unsure, if we're talking about your own practice or a business that you work within where there might be a need for expert advice, then please do reach out to Euan. I think that's really, really important. Euan, Adam, are just looking at the thanks and the notes. Some very much people saying thank you very much indeed. Good session and very much appreciated. So thank you to you both. I'm just looking at the Q&A. No, I think we've covered those, and as you say, one of them was just a thanks anyway. So Euan, Adam, thank you both very much indeed for your time and for the presentation this morning. We will share slides with everybody, but please remember these slides are as of today's date, so please do bear that in mind. I've just got two things to mention to members who are online with us. One is about renewals. Your membership renewal. If you have not renewed your membership, can you please make contact with the Institute with some urgency? If you have to renew both your membership and you have to renew your firm as well, if you're unsure as to whether you've done any of that, please contact the membership team. And renewing your membership is about paying fees and completing the appropriate returns. As I say, if there is anything that you're unsure of there, please contact the Institute. But we are in the final throes of the renewal process. So if you're unsure, please reach out. The other thing, this is a continuing professional development, a CPD session. Some excellent learnings delivered from Euan and Adam this morning. You've registered for this, you've attended this, you know where all of the Institute's CPD, whether it be online or in person, can be found on the Institute's website. Please do look at the CPD and the events page, and please do register for those sessions that you think could be useful, helpful and supportive. If you like your face-to-face events, just to mention, Northern Ireland tomorrow, Scotland on the 24th of April, and the north of England on the 18th of April are the up-and-coming face-to-face events. London, the Midlands, Eastern, Southwestern Wales have already held meetings this year, and they're in the stages of planning for their next meeting before the summer break. The only other thing, the final thing from me would be just to say the London conference is on the 25th of June. All of the details are on the Institute website, so please do find it there. Thank you for attending, everybody, but especially to Euan, to Adam and to Nicola in the background. Thank you all for your time and your contributions. Wish everybody a good afternoon and look forward to seeing everybody soon.
Thank you, Jonathan.
Cheers, Jonathan. Thank you.
Thanks all. Bye-bye.